Today we discuss the top 10 mistakes in filing patent applications. So the first one is waiting too long to file. In the stages of a startup, you typically have the ideation stage, then you do your customer discovery, then you build your minimum viable product, and then you test them on the customer, and then you iterate the process. An analogous process to this is actually like Kickstarter. So what happened is in Kickstarter, you describe your idea, you raise your funding, and if the funding fails, that means your idea is not good enough. The problem with Kickstarter is often many people put full details of their ideas on the internet. And guess what? A company in a low-cost production area can just simply sit there and watch when the idea is described, and if there's enough buyers to launch the project, then they know that the company's already done the market research, and they simply just do the design in a faster, quicker, they call it a fast copier company strategy. Right. And when you do that, you can just run somebody else's market test and you can just produce the original company. And so that's a problem if you use the Kickstarter approach without IP protection. So a much better way is before you talk to the customer, you have a provisional application that protects your idea. And then once you've gone through product validation and you start the product design, at that stage, you might want to consider a second patent application to cover particular implementation before you release it to people for testing, right? And you do several of these iterations of provisional until you got through a full testing period with the customers and you're ready to launch. Take all of those provisional applications and roll them into a non-provisional patent application, and you've gotten the optimum protection. People can't just simply copy your ideas as you go along. So the second mistake is under-describing the invention. Many people file a provisional as a one-pager, and so when you file the idea as a one-pager, it's so high level that practically anybody in the universe, when they try to solve this problem, they're probably likely to go down the same path. So the more details you describe about your particular patent, your invention, the better you are. And I tend to like to see around 20 to 30 pages in a provisional application. And certainly you should leverage the use of graphics. As they say, one picture is worth 1,000 words. And if you are not very good at writing, then a lot of pictures of your invention. If you have it built or describe your product, you just take pictures of your prototype. In the case of software, you might just want to consider pseudocode, i.e. high-level code that describes how your system operates. And all this could be generated these days very, very easily using AI and software tools. You should not be under-describing the invention. The other advantage of being fully inclusive in describing the invention is that you lay the foundation for the future. A patent will live for 20 years, and you might have descendant from that patent, right? So you might have different embodiments serving different applications. For example, your initial beachhead might be a consumer application, but this technology could be applied to agricultural technology, or it could be applied to clean technology, for example. And so if you describe 10 different embodiments in a thick application, let's say 100 pages, because these applications live over a 20-year lifespan and you can draw continuations from them, your applications could be sequentially directed at different uses, and that way you splice the market into small chunks, similar to the calculus integral formula, right? You can have applications that cover different slices of the market that when you sum up, give you the optimum market size. So you should fully describe and think around how somebody could redesign around you. So another mistake is overclaiming or underclaiming. When you do your non-provisional applications, you require a claim or a set of claims. So the claim should be done just perfectly right. It needs to be just broad enough to avoid the prior art, i.e. you just need one differentiation feature to distinguish it from the prior art. But you don't want to be too many features so that it's harder for you to enforce your patent because the claim is like an and, right? So for example, if you claim an invention with elements A and B, you can use A and B to cover anything that has A and B in it. But if you claim A, B, C, D, and E, You cannot go after a product that has only A and B features. And that's an example of the breadth. So the longer the claim, the narrower it is. But the easier it is to get a patent because the examiner has to now match the prior art against all the elements of the claim. So there needs to be a balance. And the proper claim breadth is very hard to achieve. So what I recommend is a series of claims so that you have, let's say, A and B, and then A prime, B prime, and then ABC, ABC prime, different variations of that. That way, in case accidentally A and B, the claim with A and B is met by the prior art, you can always go and shift into the variations of the claims. That's the easiest way to avoid the overclaiming or underclaiming problem. And that's how you also deal with the prior art search with unknown prior art. Another mistake is ignoring international strategy. So these days products are global. Initially, I would definitely recommend if you're a US citizen, definitely patent in the US. That's the cheapest way to get patent protection. But if you know that your market's going to be global, then you want to think about where can I sell my products? If it's a consumer product, it's going to be in the big areas of Europe, China, Japan, Korea. Those are definitely large, rich consumers that would buy the product. So consider those. However, if you're in the tech space, maybe you don't need to go everywhere. Maybe you just have to target the agricultural rich regions, and that would be US, Ukraine, Brazil, and South America. So you don't have to go to the popular countries. So the choice of country selection depends on where the consumers are and also on the cost, things like that. Another mistake is a template to do your patent application. At a minimum, I recommend that if you lack money, resource, use an AI software like Power Patent that at least gives ensures the minimum requirements are met. Software needs to be driven by somebody who's experienced, and so the optimum region is when you use a software to do the first draft, then you consult with an attorney, and that process improves the quality and reduces cost. And also you can do it a lot quicker now because if everything is on paper, the attorney can read it and he or she can come up to speed much faster versus starting from nothing. So that's one way to improve your patent application is to use AI software at the minimum or work with a law firm that uses AI technology to cut your costs. Yet another mistake is a silent killer mistake, is not thinking about enforceability of the patent. Many inventors fall into the trap that, I'm going to have a patent so that I have a nice plaque on my wall. That's not the way to think about patents. It's a tool to be used to extract value for your business. Or if you don't run a business, extract money for you. It's called monetization. So when you look at a claim, you need to also consider who would be likely to use this claim, who would likely be able to practice or infringe it, right? So review the claim with infringement in mind, number one. Number two, review the disclosure so that it supports downstream design around of that particular claim. So if you think through carefully enough and you block all exit paths, so when you come and enforce and monetize your patent, you're going to find out you're going to get a lot more money made. So my view, you need to think about a patent as a monetizable asset and not as a plaque on the wall. Hopefully these ideas will give you the guidelines to create a valuable patent portfolio. And if you have any questions, feel free to reach out. We look forward to helping you.